the introduction words, and I'm really glad that I can participate in this initiative. And beside this, I must express my admiration to our Hungarian host for being in position to establish such organization as Central European Professors Network. I'm a little bit jealous because we in Slovenia, we are not in the same position, and we don't enjoy such support of the government because the legal research is somewhere very, very low in research priorities, and we cannot compete with natural sciences, technical sciences, and even other social sciences. So the legal research is somewhere below the bottom sometimes, and it's really great that it's a little bit different in Hungarian. So, however, Vasilka gave you quite a comprehensive introduction to Slovenian constitution and right to healthy environment, which is part of it. And I would like to stress some other points in my presentation regarding the use of constitutional rights in praxis. I'm not a constitutional lawyer. My field of law is private law, property, contracts, and torts. And I will try to show you how some constitutional rights and practice are also very important for the development of classical private law institutes, especially in the tort law. So, Vasilka mentioned the most important fundamental right in our constitution, the right of healthy environment, in Article 72 of Slovenian Constitution. I will skip the adjective, what does it mean, living environment. It has been explained, but it's quite important what was stressed by Vasilka, that the Constitutional Court deals with this right as with the fundamental human right. What will be quite important in our case, which will be represented, because it's important for the establishing of damages. So there's another quite important provision in the Slovenian Constitution, Article 15, speaking about the limitation of the fundamental rights. I will not go in the details of this provision. As I said before, I'm not a constitutional lawyer. I'm not an expert for this topic. But however, of course, the human rights could be limited with public interests or with equal rights of other people. Here we have a picture of protests on our streets in early 90s. Slovenia got independence, and one of the consequences was that our position a little bit changed in the Europe. Also the Europe changed at that time, and in very short period of time the transit over the country changed. Before, the main traffic road was from north to south, and later the traffic went from west to east, from Italian border to the whole country to the Hungarian border. And of course it's impossible to build a highway so quick, and we have a number of small towns and villages with a really heavy traffic with the trucks. No highway, no way beside the living area, heavy traffic through the center of living areas, and of course the people began with protest. It's a natural defense against such violence of their privacy and their peace in home. And in this case, we have the regulation in our civil code, in obligation code, the article 133 says that everyone could claim the prohibition of activities which could be disposed as a source of danger or with other risks. Of course, such heavy traffic is a cause of dangers, and in principle, the people who were attached by the noise of this heavy traffic could claim the prohibition. But of course, there are exemptions. We have Article 3 of the same provision, which says that if damage arises during the performance of generally beneficial activities for which permission has been given by the relevant authority, the prohibitive claim is not allowed, but in this case the people can claim the damages, but only the damages that exceeds the customary boundaries. Okay, good. It's quite clear the main road shouldn't be closed because of uncomfortable feeling of some neighbors, and the tracks drove and drove and drove, and of course some damages occurred. For example, our obligation code regulates also the question of damages, and in Slovenian legal system we know two types of damages. The first one is material damage, and we consider the material damage every damage in the property, so-called ordinary damage, and the lost profit. And the other type of damage is so-called immaterial damage, and the immaterial damage shows in infliction of physical or mental distress. Okay, and it's quite interesting that Article 179 of the Obligation Code says that the mental distress could also be the breach. The truncation is its official, partial official translation for Obligation Code. I believe the breach is much more proper expression. The breach of freedom or a personal right. And because of this reason, because of this breach, the people, the claimant, could claim the immaterial damage. Of course, with this heavy traffic, we have a number of cases in these small towns. There are also poor houses, and we can see some cracks in the walls, and it's quite clear that if we have cracks in the walls, that in this case the claimant, the owner of the house, can claim the damage from the state to repair the house. But some people don't have such consequences. Thanks God, it's quite serious problem if you have crack in your wall. But sometimes, and mostly, people don't have material damage because of heavy traffic. So some locals who have their houses along these roads start claims for immaterial damage. And here is the basic legal question, fundamental legal question. Is the right to a healthy living environment a fundamental human right in the sense of Article 179 of our obligation code? What enables court to give the monetary compensation for mental distress? This was quite a serious legal question in our case law. It's quite often discussed. Of course, in many legal disputes we have some authors who are for this solution and some authors who are against. But what is most important, the Supreme Court, a little bit early in 1993, not the same case, have already decided that the right of healthy environment of Article 72 of Slovenian Constitution is also, it's not only a fundamental human right, but it's also a personal right. And because of this, the concept of mental distress should be interpreted broadly, what means that because of breach of fundamental right of healthy environment, the people also can claim the immaterial damage for mental distress caused by this breach. And for the consequence, for example, we have number of case law regarding this question, and example for time for 57 months from January 2004 to October 2008, the owner of the house 6 meters away from the road got the compensation, the monetary compensation of approximately 5,500 euros. Fortunately, in October 2008, the highway was opened and the heavy traffic went to the new highway. But of course, such approach of the case law encouraged some law firms to offer some type of class action against the state. It's quite popular now in Slovenia to claim the damages from the state from different reasons. And I'm quite sure that in the future, because of our environmental reasons, we can expect even more such cases. Thank you very much.